Okay, so selection of the charge is the second section in Chapter 10, the decision whether to prosecute. If the prosecutor has decided upon prosecution, there often remains the question of what the charge should be. Sometimes this is a simple matter of whether the charge should be of a greater or lesser crime. For example, felony burglary versus misdemeanor breaking and entering. On other occasions, the prosecutor must determine whether to charge a defendant with more than one offense, either because the defendant has committed a series of offenses, example, a number of burglaries over time, or because the defendant violated more than one statute during a single course of conduct. In the third situation, the defendant's challenge, as in United States versus Batchelder, may be grounded primarily in the contention that the applicable statutes improperly overlap. So that's the third situation. One was the greater or lesser crime. Two was more than one offense. More generally, as the second case in this section, United States versus Goodwin, a defendant might challenge the prosecutor's charge selection decision on the grounds of actual or apparent vindictiveness. United States versus Batchelder, a 1979 case. Justice Marshall delivered the opinion of the court. At issue in this case are two overlapping provisions of the Omnibus Crime Control and Safe Streets Act of 1968 and the Omnibus Act. Both prohibit convicted felons from receiving firearms, but each authorizes different maximum penalties. We must determine whether the defendant convicted the offense carrying the greater penalty, but may be sentenced only under the more lenient provision, which his conduct violates both statutes. Is that the issue? It sounded like terrible. We must determine whether a defendant convicted of the offense carrying the greater penalty may be sentenced under the more lenient provision when his conduct violates both statutes. So, which do you want to charge him with? Respondent, a previously convicted felon, was found guilty of receiving a firearm that had traveled the interstate commerce in violation of 18 U.S.C. Section 922. The district court sentenced him under Section 924A to 5 years imprisonment, the maximum term authorized in violation of Section 922H. The Court of Appeals affirmed the conviction, but by a divided vote, remanded for resentencing. The majority recognized that respondent had been indicted and convicted under Section 922H and that 924A permits 5 years imprisonment for such violations. However, noting that the substantive elements of 922H and 18 U.S.C. App Section 1202A are identical as applied to a convicted felon who unlawfully received a firearm. The court interpreted the Omnibus Act to allow no more than 2-year maximum sentence provided by Section 1202A. And I believe the rule, if anyone are interested, it's on page 661. It's kind of long, but this is not going to be a long recording, so I'll read it. In pertinent part, 18 Section 922H provides it shall be unlawful for any person, one, who is under indictment for or has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year, two, who is a fugitive from justice, three, who is an unlawful user of or addicted to marijuana or any depressant or stimulant drug or narcotic drug, or four, who has been adjudicated as a mental defective or who has been committed to any mental institution, to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. Section 1202A states, quote, any person who, 1, 2, 3, 4, 5, here you go, 1, has been convicted by a court in the United States or of a state or any political subdivision thereof of a felony, or 2, has been discharged from the armed forces under dishonorable conditions, or 3, has been adjudged by a court of the United States or of any state or political subdivision thereof of being mentally incompetent, or 4, having been a citizen of the United States, has renounced his citizenship, or 5, being an alien is illegally and unlawfully in the United States. And who receives, possesses, or transports in commerce or affecting commerce after the date of enactment of this act, any firearm shall be fined not more than $10,000 or imprisoned for not more than 2 years or both, from 18 U.S.C. App Section 1202A. Now, this court has previously noted the partial redundancy of Section 922H and 1202A, both as to the conduct they prescribe and the individuals they reach. However, we find nothing in the language structure or legislative history of the Omnibus Act to suggest that because of this overlap, a defendant convicted under Section prison for no more than the maximum term specified in Section 1202A. As we read the Act, each substantive statute, in conjunction with its own sentencing provision, operates independently of the other. So, in resolving a statutory question, the majority below expresses serious doubts about the constitutionality of the two statutes that provide different penalties for identical conduct. Specifically, the court suggested that the statutes might, 1, be void for vagueness, 2, implicate the due process and equal protection interest in avoiding excessive prosecutorial discretion and in obtaining equal justice, and 3, constitute an impermissible delegation of congressional authority. We find no constitutional infirmities. It is a fundamental tenet of due process that no one may be required at peril of life, liberty, or property to speculate as to the meaning of penal statutes. A criminal statute is therefore invalid if it fails to give a person of ordinary intelligence fair notice that his contemplated conduct is forbidden. So too, vague sentencing provisions may pose constitutional questions if they do not state sufficient clarity the consequences of violating a criminal statute. The provisions in issue here, however, unambiguously specify the activity prescribed and the penalties available upon conviction. That is, particular conduct may violate both titles, does not detract from the notice afforded by each. Although the statutes create uncertainty as to which crime may be charged and therefore what penalties may be imposed, they do so to no greater extent than would a single statute authorizing various alternative punishments, so long as overlapping criminal provisions clearly define the conduct prohibited and the punishment authorized, the notice requirements of the Due Process Clause are satisfied. This court has long recognized that when an act violates more than one criminal statute, the government may prosecute under either, so long as it does not discriminate against any class of defendant. Whether to prosecute and what to charge or to file or bring before a jury are decisions that generally rest in the prosecutor's discretion. The Court of Appeals acknowledges a settled rule allowing prosecutorial choice. Nevertheless, the court distinguished overlapping statutes with identical standards of proof from provisions that vary in some particular. In the court's view, when two statutes prohibit exactly the same conduct, the prosecutor's selection of which of the two penalties to apply would be unfettered. because such prosecutorial discretion could produce unequal justice, the court expressed doubt that this form of legislative redundancy was constitutional. We find this analysis factually and legally unsound. So the opportunity for unfairness is not synonymous with a constitutional infirm. Contrary to the Court of Appeals assertions, the prosecutor's discretion to choose between those two sections is not unfettered. Selectivity in the enforcement of criminal law is, of course, subject to constitutional constraints. And the decision to proceed under Section 922H does not empower the government to predetermine ultimate criminal sanctions. Rather, it merely enables the sentencing judge to impose a longer prison sentence than Section 1202 would permit, and precludes him from imposing the greater fine authorized by Section 22 or 1202A. More importantly, there is no appreciable difference between the discretion a prosecutor exercises when deciding whether to charge under one of the two statutes with different elements and the discretion he exercises when choosing one of two statutes with identical elements. In the former situation, once he determines that the proof will support conviction under either statute, his decision is indistinguishable from the one he faces in the latter context. The prosecutor may be influenced by the penalties available upon conviction, but this fact alone, standing alone, does not give rise to a violation of the Equal Protection or the Due Process Clause. Just as the defendant has no constitutional right to elect which of the two applicable federal statutes shall be the basis of his indictment and prosecution, neither is he entitled to choose penalty scheme under which he will be sentenced. Approaching the problem of prosecutorial discretion from a slightly different perspective, the Court of Appeals postulated that the statutes might impermissibly delegate to the executive branch the legislator's responsibility to fix criminal penalties. We do not agree. The provisions at issue plainly demarcate the range of penalties that prosecutors and judges may seek and impose. In light of that specificity, the power that Congress has delegated to those officials is no broader than the authority they routinely exercise in enforcing the criminal laws. Having informed the courts, prosecutors, and defendants of the permissible punishment alternatives available under each title, Congress has fulfilled its duty. So, United States that's it. No dissent, concurrence, anything at this point. U.S. versus Goodwin is the next case, and it is not short. But it is the last part of Chapter 10, so I'm going to do it another recording, if we record at all.